Good morning. Please be seated. Yes.
Good morning, my Lord. Good morning, Mr. President, and good morning, members of the board. My Lord, Mr. President, and members of the board, the prosecution will at this stage conduct their closing address. Mr. President and members of the board, all 26 accused persons standing before you this morning are serving members of the Republic of Sierra Leone Armed Forces. And we are here this morning, Mr. President and members of the board, to remind you of their participation in the incidents leading up to the 26th November 2023 and the unfortunate activities culminating from their participation of those incidents leading up to November 26, 2023. My Lord, Mr. President, and members of the board, it is our submission that the acts and conduct of all 27 accused persons before you violated the laws of this country, more particularly as provided in the acts creating the Republic of Sierra Leone Armed Forces, consisting of the guiding principles as to how a military personnel trained and enlisted should and must carry himself. My Lord, Mr. President, and members of the board, you could recall that the states in January preferred charges against 27 serving members of the Republic of Sierra Leone Armed Forces. And having conducted the commander's investigation, it was indeed recommended by their various commanders that they should all stand trial before this court-martial. And subsequently, my Lord, Mr. President, and members of the board, they all 27 were charged. And during the course of these proceedings, when the charges were put to them, Mr. President and members of the board, you could recall that the first accused had pleaded guilty to some of those counts. They also pleaded not guilty to some of the offenses charged in the counts in the charge sheets, Mr. President and members of the board. It was based on his guilty plea that the states graciously decided to drop the remaining counts, and this court-martial convicted that first accused, and he was accordingly sentenced. And Mr. President, members of the board, as it were, when he pleaded guilty and subsequently convicted, we are now left with the 26 accused persons before you and the stand charged with 39 counts of committing a civil offense, 7 counts of mutiny, 7 counts of aiding the enemy, 24 counts of communicating with the enemy, 2 counts of stealing of public or service property, 2 counts of fraudulent misapplication of public or service property, 2 counts of receiving public or service property, 1 count of retaining public or service property, 1 count of willful damage of public or service property, and 1 count of conduct to the prejudice of military discipline and good order, all subject to provisions in the Armed Forces of the Republic of Sierra Leone Act of 1961 as amended. Mr. President and members of the board, you could recall that after the state dropped the remaining charges against the first accused who pleaded guilty, we had proceeded to give this court evidence relating to the first accused, which by his admission informed this court as to how plans were made and eventually executed leading to the incident of November 26. That, among others, Mr. President and members of the board, the state will this morning remind this honorable court-martial as to not just what the first convicted accused did, but what he did in concert with his co-accused standing trial before you this morning. And to that end, my Lord, Mr. President and members of the board, the case against the remaining 26 accused persons before you is that they've all acted jointly and or separately. Jointly, I say, amongst themselves, the first convicted accused and others that are not before you. Separately, I mean as individuals. To engage in the acts alleged by the state against them, which the state believes amounted to serious violations of their guiding principles. My Lord, Mr. President and members of the board, at this stage I must hastily say the state has successfully led evidence beyond reasonable doubt with regards each and every allegation contained in the charge sheet before this court-martial against each and every of the accused persons before you, to warrant the convictions. Before going further, Mr. President and members of the board, I must say, at this stage of the trial, this court-martial must be reminded that it is the duty of the states to prove the guilt of the accused persons before you beyond reasonable doubt. And Mr. President and members of the board, beyond reasonable doubt would not mean beyond every shadow of the doubt, but rather you, Mr. President, and members of your board must be very sure that the accused did what the state is alleging. And how can you arrive at that conclusion, Mr. President and members of the board? It is not out of inference or things stated outside this courtroom, but what you heard, what you saw, and what you might be reading when you return for your deliberations. Again, what you might have seen or what you might have heard inside this court must be from that witness stand or from the dock where some of the accused testified before you. Further exhibits were tendered, screened. Those are the things that should guide you in arriving at your conclusion as to whether the state has proved the guilt of the accused beyond reasonable doubt. Mr. President and members of the board, the flip side would be if the state has not been able to establish that the accused did what is alleged, it is your duty to return, deliberate, and come back and return a verdict of not guilty. That is your responsibility, Mr. President and members of the board. Having listened to the evidence, having reviewed what is before you, if you are not sure that the accused did what is alleged, humbly crave your indulgence to go deliberate and return not guilty verdict so they can go home. However, Mr. President and members of the board, if you are sure, having listened to the witnesses that testified before you, having gone through all of the exhibits tendered in this court, you are of the opinion that the accused did what is alleged, it is your honorable duty to go, deliberate, and return a verdict of guilty. Mr. President and members of the board, with regards to your responsibility as to how you arrive at the conclusion that the state has established or proved the guilt of the accused beyond reasonable doubt, it is the duty of the state to have established during the course of this court-martial, which started on the 8th of January, each and every element of all of the offenses charged in the charge sheet that is presently before you. Mr. President and members of the board, again with respect, I'll remind you, we have successfully led evidence to show that the convicted first accused had connived with some of the accused persons and others who are not before you to unlawfully take arms and ammunition that was under the control of that first convicted accused while he was serving as the officer in charge of the Fudia Forward Patrol Base in Cambia. And those arms and ammunition were unlawfully used by him and his co-accused to carry out series of attacks, which included the Cockrell Barracks, the Joint Logistics Unit, the Pademba Road Correctional Centers, among others. By engaging in those conducts, Mr. President and members of the board, military personnel were killed, police officers were killed, civilians were brutally killed. As part of the plans, the first accused told you that he had facilitated the movement of some of the accused persons and others that are not before you to a village to visit a herbalist, where they were given charms, believing they will be immune from gunshots. And it was after that mission that the first, fourth, and fifth accused persons later devised their plans as to how they can get arms and ammunition that were under the control of the convicted first accused, come down to Freetown, where some of the other co-accused were already waiting to execute the plans of the late night of 25th and early hours of 26th November 2023. My Lord, Mr. President, and members of the board, the scheme was further having the 21st accused traveling from McKinney to Freetown, where he served in the military parlance in a position called Reki. Ordinary English will mean recognizance, a spy, awaiting the arrival of the co-accused, and also giving them information as to the whereabouts and movement of loyal forces of the Republic of Sierra Leone Armed Forces. Mr. President and members of the board, that scheme graduated into running to Wilberforce Barracks, not to stay in the billets, but to launch an attack on the arms store located at the Wilberforce Barracks, where the 17th accused person was the commander. Mr. President and members of the board, I will come to the duties and responsibility of a commander later on in the closing address. But at this stage, it is our submission that the 17th accused, being the commander, failed to prevent the attack to his arms dome. And in the midst of such failure, even if he were to tactically deny his responsibility, he failed to suppress the attack or to repel the enemies who had broken into a sacred building of the Republic of Sierra Leone Armed Forces. Mr. President and members of the board, all 26 accused persons abdicated their professional duty as military personnel. They had used violence to attack military installations, killing, as I've said, military personnel, police officers, and civilians. They systematically grew in number, Mr. President and members of the board, but they eventually met their match by loyal forces of the Republic of Sierra Leone Armed Forces. They were eventually repelled. Some of the accused persons, knowing that they have embarked on a failed coup mission, decided to return back to their various bases. It is our submission, my Lord, Mr. President, and members of the board, that the accused engage in acts of mutiny and further failed to prevent such conduct of mutiny, and the state has led sufficient evidence beyond reasonable doubt to support the allegations that are contained in the charge sheets before you. My Lord, Mr. President, and members of the board, will now turn to the charges against the accused persons. And I'll start with the offense of committing a civil offense as provided for in Section 72, subsection 1 of the Armed Forces of the Republic of Sierra Leone Act of 1961 as amended. And the act, that section, Mr. President and members of the board, provides, with your leave, my Lord, any person subject to military law under this act who commits a civil offense, whether in Sierra Leone or elsewhere, shall be guilty of an offense on against this section. And by that section, Mr. President and members of the board, a civil offense means any act or omission punishable by the laws of Sierra Leone, or which, if committed in Sierra Leone, would be punished by any such law. With respect to the charge in that particular offense of committing a civil wrong, the state has charged the accused with the offense of conspiracy. And Mr. President and members of the board, conspiracy in law is an agreement between two or more people to do an unlawful act, or to do a lawful act, but you do it by an unlawful means. So the definition is such that if you are in agreement with at least between two people to do something that the law says no, you should not do, or to do something that the law says yes, this is what you can do, but then you do it through the back door, that is conspiracy. Mr. President and members of the board, As I've stated, agreements between two or more people can be conspiracy, especially if they have something they are working towards. I must state, with regards to the offense of conspiracy, Mr. President and members of the board, one need not be present for you to have conspired successfully with somebody else. So, for example, two people can conspire, can be in agreement in Freetown, and the one will leave Freetown for Kabbalah to carry out the agreement. The one staying back in Freetown can be equally guilty as the one leaving to execute the plans in Kabbalah. Again, Mr. President and members of the board, we must submit that for an offense of conspiracy to hold, the states must prove that the parties to that agreement did something in furtherance of the agreement. And how that can be established, the mere agreement is in itself an offense. So you need not take step to actualize the agreement, but by agreeing, you are in fact guilty of the offense of conspiracy. Mr. President and members of the board, again, I must remind you that conspiracy involves mental elements, in that the states, in proving the agreement, which can be signified by your conduct, by communication, by sending messages, we must also prove the mental state of the person entering into the agreement. And that is the intention to carry out, firstly, either the unlawful acts or to carry out a lawful act by unlawful means. And zooming in on the definition already given, Mr. President and members of the board, the states or the doctrine can also rely on what is referred to as act and declaration principle. The definition has stated an agreement between at least two or more people. If one comes up and says, I agreed with my colleague to steal, that is the doctrine of act and declaration. They were both in agreement, and one person is now saying, we agreed to go and steal. With that principle, Mr. President and members of the board, coming from one of the conspirators, a court can convict for the offense of conspiracy. If the court believes the declaration of that particular conspirators. In summary, with regards that particular offense of committing civil wrong, Mr. President and members of the board, the states must prove that at least two or more people, and in this case we have 26, which falls perfectly well into the definition of having at least 2 or more people entering into an agreement. The states must prove that all 26 people were in all 27 who were initially before you were in fact in agreement between themselves and others that are not before you. Secondly, that at the time they entered into such agreements, they were serving members of the Republic of Sierra Leone Armed Forces. And based on the definition given and the criteria set out in Section 72, we must prove that they have committed that particular civil offense, which in this case was conspiracy. Secondly, my Lord, Mr. President, and members of the board, the state has charged the accused persons with the offense of mutiny. Mr. President and members of the board, the offense of mutiny is provided for in Section 37(1)(a), 37(1)(b), and 37(2). And again, Mr. President and members of the board, to remind you of that provision, which you leave, my Lord, any person subject to military law under this act who takes part in a mutiny involving the use of violence or the threat of the use of violence, or having as its object or one of its objects the refusal or avoidance of any duty of service against or in connection with operations against the enemy, or the impeding of the performance of any such duty or service. And B, Mr. President, any person subject to military law under this act who incites any person subject to service law to take part in such a mutiny, whether actual or intended, shall, on conviction by court-martial, be liable